SJC-11775, Commonwealth v. Claus L. Jones.
Good morning. May it please the Court, Kathleen O'Connell for Mr. Jones. I'd like to begin with the public trial issue. Mr. Jones's Sixth Amendment right to public trial was violated when the trial court closed the courtroom during a rape shield voir dire without conducting any inquiry under the Waller versus Georgia case.
As I understand it, 49 or 50 states, the District of Columbia, and the federal government all have a rape shield statute, correct?
That's right.
So, correct me if I'm wrong, but the Connecticut case and that statute's very different. There's no cases suggesting the result that you're saying, are there?
I believe the Ravitsky versus McCaskill case, that's the, I may have that one. I may be mixing it up with another case. There are a couple of cases that they're cited in my brief, that have come to the conclusion that it violates the defendant's right. But the point here is that the in-camera provision of the statute that was interpreted as requiring the courtroom to be closed here, it need not be interpreted that way. It could be interpreted as a hearing out of the view of the jury and not simply out of the view of the entire public. That provision basically...
Why does that advance the purposes of the rape shield law?
Why does allowing the public to attend... Well, it's not so much that it advances the purposes of the rape shield law. It's whether or not the purposes of the public trial guarantee are observed in observing the statute. That basically the public could be allowed under certain circumstances, but the point here is that there's no opportunity to even balance those interests where it's a mandatory closure by statute, which has been said by the Supreme Court is disapproved in Globe newspapers.
So if the jury were not present in the courtroom and the courtroom was open to the public and this hearing took place at the sidebar out of the hearing of everybody, that would have been okay?
Well, I don't know whether it would have been okay or not. I think that there has to be a balancing of the interests here. I think that there are other alternatives that the trial court could do, including having the hearing at sidebar. That may be difficult where you're calling witnesses, of course. But in this case specifically, the sort of less onerous closure would have been to allow the 2 or 3 family members that were present to remain in the courtroom.
Could you refresh my memory? Was this a hearing that took place prior to, in the middle of the trial, or at what point did this happen?
It was at the preliminary stages of the trial.
But the jury had been
the trial
chosen.
had not actually.
The jury had been chosen.
The trial had not actually started. Is that right? It's a pre-trial motion in limine. Is that what it was?
It could. I think that whether or not the right applies to this doesn't hinge on whether we call it a pre-trial or a during trial. I think that you have to look at the interests at stake and the objectives of the right and whether they're served. But of course, you could call it a pre-trial hearing. The jury had been picked.
But had the jury been sworn? Had the jury been sworn?
I don't believe that the jury had been sworn. I could be wrong about that. But clearly, we know that the application of the right doesn't hinge on whether the jury has been sworn or not. The Waller case, obviously,
the public trial right attaches to a trial. I mean, are you suggesting that if we had a motion to suppress, for example, that right before trial, which happens in some courtrooms, that the public trial right would apply in that situation?
Absolutely. The Waller case was a suppression hearing. So absolutely the public trial right would apply to a suppression hearing. And to many courts, I will willingly concede that there is absolutely no bright line test here that has been delineated from all of the different courts looking at this question. But certainly, pretrial hearings have been included. The right has been applied to them. Suppression hearings, jury selection itself. Obviously, the jury is not sworn during jury selection.
Okay,
So,
that's a fair point. Well, let me just ask you, why doesn't the operation of the rape shield statute sort of supply the Waller factors that you would normally address in a situation like this? I mean, you have all of the answers to the questions in the rape shield statute, right?
well, certainly the Supreme Court precedent has been very clear that we can't have closures by policy or closures by statute. It's certainly possible, and in fact, in the Globe newspaper case, the Supreme Court assumed, or perhaps even held, that there was a compelling interest in the child witnesses not suffering psychological trauma. However, they held that that wasn't enough. Even a public policy finding such as that, setting out in statute saying child witnesses are vulnerable, and certainly there was probably some findings that the legislature that went along with that before the statute or the rule was passed.
But that's very different, though, because that's the actual trial testimony that everybody conceded was relevant, in fact, essential to the case, and that's going to happen in closed setting. This is a hearing to determine whether the evidence is going to be deemed totally irrelevant, because presumptively it is, and it's only and if that decision is made that it is relevant, it is going to be heard in the public setting. So they're not the same.
Right. Well, so what I was referring to in the Globe newspaper case was whether or not the interest was compelling. And so we're really talking about, is the interest of a rape victim or of a complainant, is that a compelling interest?
Well, not exactly. I mean, because it means it's different in the sense that if the decision is made that the rights of the defendant to a fair trial and his due process rights are such that this evidence is material and relevant and he's entitled to have it admitted and to rebut the presumption that it's not relevant, it is going to be heard, and it's going to be heard in a public setting.
So I think that what Your Honor is getting at is this question of relevance, and should this be the determining factor where we say, well, the evidence was presumptively irrelevant, as the Commonwealth has argued, and that's determinative of whether we apply the right or not. I think that, number one, that's setting up a pretty broad standard where every time the trial court has a relevance determination, the public can be excluded. And I think that it's also not accurate to say that a rape shield hearing is about relevance, because now that's an argument that's often advanced, and it's an argument from the cases such as the McBail case, which is cited in both parties' briefs. The reality is rape shield hearings really are not about relevance. They're about prejudice. Quite often, the evidence that's advanced at a rape shield hearing is quite relevant under our understanding of what relevance is. This is really a hearing to weigh, is this evidence too prejudicial? Because for right or for wrong, many legislatures have made the determination that the jury is not going to be able to separate out this prejudicial information.
Every legislature has not
Fair
just
enough.
many, every.
Fair enough. Every legislature, and that may or may not be a fair point. That's not my purpose here to argue that. The jury would not be able to disregard this evidence. So it's not really about presumptive irrelevance. And it would be, I think, put Massachusetts in a position of being an extreme outlier to say that we're going to decide whether the Sixth Amendment right applies by saying what the subject matter of the hearing is, where, in cases such as this, there are many other trappings of a trial and many other objectives and interests at stake. The objectives of the public trial right are advancing honesty and discouraging perjury, allowing witnesses to come forward, et cetera, which the court, I'm sure, is very familiar with all of these objectives. And if we allow the standard of presumptive irrelevance to apply, then we're sort of leapfrogging over all of those interests and objectives here, where in a case such as this is not simply a case, simply a proceeding where, for example, the parties are in the judge's chambers at a lobby conference, say, or, saying, well, what's the next scheduling of witnesses going to be? This is a proceeding that has many of the trappings of a trial. Witnesses are sworn, evidence is taken, the defendant has a right to be there, has a right to question witnesses, has a right to counsel there. So it's not simply a matter of, is this a sort of administrative hearing? This is a hearing where...
But yes, but if you look at, I guess that's all true. The defendant has a right to be there, but do you look at it as sort of balancing of history and the way it has been done, or are you looking at it as it's part of the trial? Because it isn't really part of the trial.
Well,
I mean, to me, it's somewhat. I appreciate that there are many differences, but it is not unlike the kind of hearing that takes place in Martin or Pixley.
Well, so the Commonwealth advances the argument that this is a collateral proceeding. And this court and the appeals court has decided truly collateral proceedings, such as the recent Mercado case, which was a witness immunity hearing, where the defendant didn't even have a right to be present, to participate. Now, that's a truly collateral proceeding. I find it difficult to understand the argument that this is a collateral proceeding where the defendant has many rights, as I've just said, right to be there, right to counsel. The legal arguments are made to the court. The judge is making decisions that will affect the balance of the trial. So all of the objectives of the Sixth Amendment right come into play here, where the public needs to be able to see what's going on. The participants in the trial need to be reminded of their weighty role here. So although it could be called many things, could be called a pretrial proceeding, it could be called a motion in limine proceeding, any of those sorts of things. It doesn't make it a truly collateral proceeding. It is still an important part of the trial that will affect the balance of the trial.
But even if it is a motion in limine, the purpose of the statute, at least in part, is to say we don't want to burden those persons who make allegations of sexual assault by the price being that their previous sexual conduct becomes a matter of public record. But if you're right, it would be.
Well, no, it would simply be subject to the balancing test under Waller. Now, what the statute can't do is make that decision presumptive.
But that's always the issue. I mean, wouldn't it be? I mean, you can say that, but under Waller, if you're trying to protect the purpose of the statute, the decision's going to be made every time, isn't it?
Well, no, I disagree with that, because certainly in situations like jury selection, the balancing test may become perfunctory, I grant, but the balancing test will still need to be weighed and decisions will have to be made, and there's an opportunity, including the waiver of the defendant, there's an opportunity for lesser intrusive solutions to come into place, such as admitting one or two family members.
Well, no, that's not. I think that's not accurate. In the sense that I think there's case law from the First Circuit anyway that despite In re Oliver that family members aren't somehow above the rest of the public. They are part of the public. So I don't think that you can get there through that.
I agree with Your Honor that there have been cases that say that they are, and there have been cases that say that there aren't, and I'm not really advancing an argument that family is more important than anyone else. Perhaps more important than the press, but we're not talking necessarily about the First Amendment.
Could you just, when you get a moment, tell us how other courts with states that have similar rape shield statutes have dealt with this issue?
Well, certainly the McBail case has found that the presumptive irrelevance is what controls. Other cases have found that there has to be a weighing under Waller. And what I'm talking about here is not so much that that this is not an important interest and that the legislature was wrong and that we should always subject complainants in these sorts of cases to, an entire public viewing, but that there has to be a weighing of these interests. Clearly, the defendant has an important interest. Perhaps this court will find in this case or in another case that there's a compelling interest on the part of the complainants. But the fact that there's a compelling interest does not allow a statute to leapfrog over that weighing that has to be applied.
Thank you.
Thank you.
Good morning. Ellen Lazar-Moore for the Commonwealth, and with me is Michael Shannon, who wrote the Commonwealth's brief. Judge Vigordoni properly closed the courtroom during the Rape Shield hearing because the statute required it, and the right to a public trial did not apply at this hearing.
Could you tell me, is there, because I don't think the McCaskill case is exactly the same as this, and I may just have missed it, is there in these 50 states and the federal government, is there a case that has said that Rape Shield falls to Waller, in a sense?
I believe the case cited from Connecticut, the Kelly case, but that statute is different.
Completely.
So of the statutes, and as Your Honor noted, there are approximately 50 jurisdictions, all of which have Rape Shield laws. Of those, more than 40 of them require that any Rape Shield hearing be held in camera. Of those states that statutorily require an in-camera hearing, no, I haven't found any that say, and then you have to apply the Waller factors.
Of the 40, has any state court said that the Rape Shield statute is okay, that it'll survive the Sixth Amendment?
Yes, Your Honor, and I cite several of those in my brief.
North
McNeil,
Carolina and
McBail,
somewhere else. Yeah.
Oregon, North Carolina. There's a case out of the First Circuit under the federal law. And there's good reason for upholding that, because the Rape Shield law categorically excludes evidence of a victim's other sexual conduct unless the defendant can meet very narrow exceptions. So at a Rape Shield hearing, the judge is screening evidence that is presumptively irrelevant and inadmissible.
But that happens oftentimes in motions in limine.
I don't believe it does, Your Honor, not with evidence that is presumed to be inadmissible and irrelevant. There are certainly motions in limine where a defendant may be making an offer of proof about, or an opponent about evidence that they want to admit, but not where there's been a legislative determination that this is presumptively inadmissible and irrelevant evidence, and a judge is screening that. If the judge decides that the defendant meets one of the exceptions to the law, then that evidence can be admitted at a public trial. But there's simply no reason to have this sort of screening process open to the public. Attendance of the public at one of these hearings would not serve the purposes of the Sixth Amendment. There's no need for the public to be present to ensure that a defendant is not wrongfully convicted or to remind triers of facts of their duty, and it would certainly not encourage people to come forward and testify. And in fact, it would likely have the opposite effect.
But it would have the effect, insofar as the Sixth Amendment advances the interest of making sure the court is doing what the judge is doing, what, in this case, he should be doing, and isn't cutting corners and not respecting the defendant's rights or anybody else's rights. It doesn't allow for that.
No, but the defendant is present with his or her counsel, and so certainly that's a check upon the judge's behavior or discretion. And in terms of, if you look at more recently, even in the Sixth Amendment context, the courts have been applying this so-called experience and logic test to determine whether this is the kind of a hearing to which the public should be admitted. And these types of hearings fail under that test as well. Certainly, historically, there's no tradition of in-camera rape shield hearings being open to the public. And as I noted, more than 40 jurisdictions require that these hearings be closed to the public.
But doesn't
And
that
then-
go, you're not suggesting that every motion in limine hearing is closed because it's a different type? And this is essentially a motion in limine hearing.
No, I'm certainly not suggesting every motion in limine should be closed. But if you look under this experience and logic test, the first question, experience, is historically, is this the type of hearing to which the public has been open to the public?
How
And
long
the
is
answer is no.
how long is the history of the rape shield statutes? 1970s?
Yes, around 1980. So
So,
still,
and
that's several decades, Your Honor. That's not that short a period of time. But if you also look under the second factor, the logic part of that test, which is, would the attendance of the public at this type of proceeding further the purposes of the proceeding? The answer is clearly no. If anything, it would eviscerate the purpose of this statute. And it's actually a conjunctive test, and both factors, the answer has to be yes in order for this to be open to the public.
What is the purpose of the statute? Is it to protect the complainant, or is it to keep out irrelevant information?
I think it's both. It's so that a complainant is not subjected to cross-examination about prior sexual history when it is not relevant. And certainly the statute itself makes exceptions for when that evidence is relevant, and then the court, through decisions, has expanded those exceptions
Right,
to
but
show
it's
bias or
important.
motive to lie.
But the importance is that the jury not hear it.
That ultimately, it's to keep it away from the jury, but it is also to protect victims and to encourage victims to come forward to report crime. If you look at the reporter's notes to the statute, there's all sorts of discussion in the legislature about how historically victims of sexual assault have been treated and why the crime is so underreported, and this is one attempt to combat that. And so I think there are several purposes of the statute, one of which is to protect the complainant, but also to encourage people to come forward and report crime, and ultimately to prevent irrelevant and inadmissible evidence from being presented to the jury.
If I can turn you to the Mountry part of this issue, which is the
Yes, Your Honor.
reasonable impairment issue, why should not the Mountry decision apply to a case that was pending on appeal when Mountry was decided?
Because, Your Honor, that decision was not based upon, it was not a constitutionally compelled new rule. And under the decisions of this court that I cite in my brief, Clemente and Dwyer and Dagley, the court has said that new common law rules will apply only to cases tried after the date of the announcement of the decision.
But we applied Mountry to Mountry.
Yes, Your Honor, in the defendant's own case, although I will say the court then held that he would not have been entitled to the instruction based upon the evidence. It's the Commonwealth's position
And I
that-
assume you're arguing the same here.
Yes, Your Honor, both. That the defendant, because at the time this case was tried, the judge correctly instructed on the law, which was Commonwealth versus Blaish. Mountry was decided 15 months later, and so since that is only a common law rule, the defendant should not get the benefit of it. But if the court were to find that he was entitled to it, as a legal matter, he still would not have been entitled as a factual matter because there was absolutely no evidence suggesting that he was so intoxicated that he could not appreciate the victim's inability to consent. There was evidence that he had drank vodka and smoked marijuana, but the only evidence of his level of intoxication was his own testimony where he said that he had a little buzz, in his words. There was no suggestion that he was even intoxicated, and he also testified that he was aware that the victim had vomited. He said multiple times that he knew that she had had too much to drink. He knew that she had been carried into his bedroom and put on his bed and was sleeping on the bed. And so he actually showed through his own testimony that he was aware of her condition. So even if the court were to determine that he was entitled to the retroactive application of that rule, he would not have been entitled to the instruction on these facts. If the court has no further questions, I would rest on my brief, or on Michael's brief. Thank you.